Mr Deputy Speaker, can I begin, please, by praising the honourable member for raising this bill, because I think it is a very, very important issue. It's something that clearly, really irritates many, many people in Britain, and it is very dangerous. We've got to a situation where human rights is being talked about as though it was some trivial, unnecessary issue, and it's connecting people's minds with phrases like health and safety. Right? So there's a very, very sad effect. The question, however, for us today is how do we deal with this problem? So the honourable member has very eloquently explained that we have a problem, has very eloquently given countless examples of things which intuitively make many people in the British public extremely anxious, extremely unhappy with the judicial institutions, unhappy with the political institutions. And we should respect that. It might be tempting, and indeed some lawyers do, to simply say the British public isn't focused enough on the moral details of this case, isn't focused enough on the legal details of this case, and to somehow trivialise their objections. This would be unfair, because there's obviously something important, deep and intuitive going on that makes people anxious about this kind of activity under the banner of human rights. The question is, what is our solution to it? How do we look at this? And I think we have to begin with a sense of what human rights are. So, Mr Deputy Speaker, if I could politely challenge slightly the definition of human rights that has been put forward by the honourable member, without calling into question his overall point, which is that we are now in a mess. It would seem to me that we can begin with a definition of human rights that would say, to say that somebody has a human right is to say that anyone, anywhere, treated in this fashion is wronged, and that their possession of that right is not relative to the costs or benefits of upholding it in any particular case. Now, this sounds very technical, it sounds very pathetic, but it is an important thing to establish at the beginning of this debate. Human rights are based on a notion of dignity, they're based on a notion of inviolability, and they are in their nature universal. To say that somebody has a human right is a statement about their moral status. It's not a statement about their nationality. It's not a statement about their citizenship. It is to say that anyone, anywhere treated in this fashion is wronged, and secondly, although there may be a threshold above which that right could be suspended, below that threshold, their possession of the right is not relative to the costs or benefits of upholding it in any particular case. So to go from the abstract to the actual...
Giving way, but surely once there is a threshold, the right is not absolute.
This is a very important point raised by the honourable member. To give an example, the basic conception of human rights is based on a notion of human dignity, and is based on a notion that humans should be treated as ends in themselves rather than as a means to an end. In other words, it is a sort of Kantian worldview. It has an absolute view of the world on how people should be treated. But at a very extreme level, there may be a threshold in which intuitively we in this room would feel intuitively that you could suspend that right. So, to give an example, if a child, for example, was in possession of information of a ticking bomb which was going to destroy 1 million people in a city, we might feel that in that situation it was justifiable to twist the child's thumb to find out where that bomb was. In other words, there might be a threshold so extreme, and these are situations almost hypothetical, but so extreme, in which our human intuition would be that the right would be suspended. But below that threshold, the possession of the right is not a function of the costs or benefits of upholding it in any particular case. So, Mr Deputy Speaker, to give an example, it would not be justifiable in any situation to kill one individual in order to harvest their organs to save 5 other individuals.
Friend, on his first example, because he has said that it would be justifiable to save 1 million people. But the obvious question is, what about 500,000? What about 50,000? What about 10,000? What about 1?
This is a fantastic argument being made, Mr Deputy Speaker, and the argument that I was trying to make to the honourable member is that in the case of 5 or 10 or 15 or 20 people, Our moral intuition is that it is unacceptable. At another level, at the level of 1 million, our moral intuition is that it might be acceptable. This is a very, very difficult point, right? The point that I'm trying to make is that we are, in a sense, deontologists. We're absolute up to a certain threshold, but there is a certain threshold at which a utilitarian or consequentialist calculus comes in. So, before the honourable member intervenes again, it's a very important point, but before the honourable member intervenes again, as Mr. Deputy Speaker, I said just earlier, if it were a case of one person being killed to save 5, in other words, the idea that somebody could be killed, their organs would be harvested, and those organs would be used to keep 5 people alive, that would not be justifiable. Their possession of their inviolability, their immunity, their right to life is not proportional to the costs or benefits of upholding it in any particular case. There may be, hypothetically, and we almost never get anywhere near this kind of threshold, as a hypothetical theoretical point, a threshold at which a right might be overruled by a consequentialist consideration, the 1 against 1 million. But below that threshold, the possession of the right is not relative to the costs or benefits of upholding it in any particular case.
My honourable friend for giving way again, but I think he's rather sold the pass once he had this child whose thumb could be twisted. Because if, to save 1 million people, the child's thumb can be twisted, can the child's arm be broken? And we are now getting into a relative argument, and we find that there is not an absolute on this. And the same applies to the example of harvesting organs. If you can save 5 people, you may say that is not allowed. But what if you could save 5 million people from one person's death? Does that then become justifiable?
Rory, Stewart.
The honourable member has asked Mr. Deputy Speaker a question which is a very, very important question of moral philosophy. And these are questions of moral intuitions. We're trying to create, in our legal system and our moral system, something that reflects our common sense intuitions as humans. We try to interrogate them, we try to be logical, we try to go down to first principles. But our common sense intuition, I feel, is that humans have a moral status, that they are inviolable, that they have an intrinsic dignity, that they should be treated as an end in themselves, not as a means to an end. But, and this is the case of 1 against 1 million, we also have a strong moral intuition that there may be certain extreme circumstances in which it is justifiable to overrule an individual's rights, but only in the most extreme circumstances. There are different ways in which we deal with this. In the German legal system, for example, in that case, the argument would be made that although it is morally justifiable to twist the child's thumb in that situation, it is not legally justifiable. And the individual who twisted the child's thumb in the German legal system would then be prosecuted and convicted, but congratulated morally for having made the correct moral decision, if the incorrect legal decision. These things, however, are purely, in our normal lives, hypothetical. We do not come across ticking bombs. There are not children who are aware of 1 million people. In the everyday life that we live, human rights are in themselves inviolable, which is why, as we move forward to look at the case brought by the honourable member, we need to ask ourselves, what is it that's wrong with the current system? And it would seem to me that there are 4 possible answers to that question. And the honourable member has given 4 possible answers to that question. One of them, which the honourable member from Somerset has raised, is a question of sovereignty. So the first possible answer to the question of what is wrong with the current settlement on rights is a problem of parliamentary sovereignty. This is a notion, which we could explore at a bit more depth, that Parliament is sovereign, that the European Court is not acting in accordance with the British Constitution by overruling the decisions of the British Parliament. The second argument that could be made is to say that a question like prisoners voting, to take a recent and difficult question, is purely relative, that it's culturally relative. One could take a situation that would simply say the reason why the European Court should not get involved in prisoners voting is not because of sovereignty, but because it's a question that's culturally relative. I say tomato, you say tomato, you allow prisoners to vote, you don't allow prisoners to vote. These things are purely subjective, they're based in a particular cultural or historical context. The European Court shouldn't be fussing about it, The British think one thing, the Spanish think another. There's no way of resolving it. It's purely relative. The third possible argument that could be made is to say that it is dealing with subjects that are purely trivial. This argument would say that voting rights for prisoners simply don't matter. There may theoretically be a moral solution to the question of whether or not prisoners should have votes, but this is a trivial issue. It isn't something that the European Court should be dealing with. The European Court should be looking at more important issues. And the fourth argument, which is the argument to which I'm tempted to go, is to say this isn't fundamentally a problem of sovereignty. It isn't fundamentally a problem of relativity. It isn't fundamentally a problem of triviality. It is a problem of the European Court using the wrong principles to come to the wrong judgments. Mr. Deputy Speaker, will just permit me just to go through those four arguments in order to expand on them in more detail. The first argument is the argument around parliamentary sovereignty, which the Honourable Member for Somerset has dealt with such eloquence. It is, of course, true that traditionally within the British system, parliamentary sovereignty was supreme. And although Dicey talks about two things, parliamentary sovereignty and the rule of law, it is quite clear that what Dicey means by the rule of law is not what Lord Bingham means by the rule of law. In other words, the rule of law, in the conventional British interpretation, is not something equivalent to the US Constitution. It is not an independent body of law against which parliamentary statutes can be judged. It was not a situation in Britain in which an Act of Parliament could be struck down by a court on the grounds that it did not accord with the rule of law. That notion, which was a notion of the 15th and 16th centuries, that there was an independent common law which trumped the actions of Parliament, was put aside. And essentially, for the last 300 years, we have believed that Parliament is sovereign. Under this interpretation, the European Court cannot possibly be engaged in trying to subjugate the British Parliament. And at its very best, all the European Court is engaged in is an international treaty obligation in which the British Parliament has voluntarily determined that it wishes to accept the rulings of the European Court, but it can choose to ignore those rulings if it wishes, and in doing so it would not be breaking British law, it would simply be in breach of its international treaty obligations. So deep is this belief in the British mind that we are now the only advanced democracy in the world that makes no explicit distinction between constitutional law and normal law. In other words, we have a situation where, as the Honourable Member who's proposed this bill has so eloquently explained, our Constitution shifts continually over time, and at its very worst, as the Honourable Member said, it moves like a reed in the wind. It is possible for a simple majority in Parliament, for the people gathered today, to change the fundamental constitution of the British nation. Theoretically possible, in a way that it is not theoretically possible in any other advanced democracy in the world. Every other democracy has a distinction between constitutional law and normal law, so that if you wish to change the fundamental constitution, you need a special procedure. Generally, Northern European countries, there is a demand for a two-thirds majority in Parliament. Southern European countries, there's much more of a focus on a referendum. In countries such as Italy, there's interest in an intermediate vote, so the Parliament has to be dissolved, and this must be put to the electorate through a general election before the constitutional change can be introduced. All of this is designed to make it very, very difficult for a Parliament in the United States, or indeed any other advanced democracy in the world, to change a constitution. The idea is, and this is not a British idea, but the idea in all these other countries is that a government, a parliament is temporary, the people are public, and the constitution exists to protect the people from the parliament. It would seem, however, that basing our entire opposition to the European Convention on Human Rights on parliamentary sovereignty is a thing which could be made, and indeed the Honourable Member for North East Somerset has made the case, on the basis of British constitutional history, but that would be an argument fundamentally on the basis of political institutions, not on the basis of morality. It is difficult to see an ethical case difficult to see a moral case for the motion of untrammelled parliamentary sovereignty as an alternative for the protection of the inviolability of the individual's rights. Indeed, the modern notion of democracy, shared in every other advanced democracy in the world, Mr. Deputy Speaker, is a notion of democracy which combines representation of the majority with the protection of the individual's rights. I give way.
Well, to my honourable friend for giving way, I don't think he has fully established the inviolability of the individual's rights. That he has stated it, but I think not established it.
Rory Stewart.
This is a fundamental philosophical debate which the Honourable Member for North East Somerset has raised with enormous eloquence. And the answer to the question is that one cannot establish the existence of inviolable rights unless one accepts two further principles: the equality of humans, the notion that myself, Mr. Deputy Speaker, the Honourable Member for North East Somerset, and indeed somebody that we have never encountered at the other end of the Congo, is in all important respects equal in dignity and rights. This is an insight of logic, an insight of human consciousness, a basic commitment to the notion that although we may feel that we are special, although we may be tempted to feel that we are the only people that exist, as we become adults, we acknowledge that other people are themselves independent moral actors who possess exactly the same dignity. The inviolability, the rights of the human being, which the Honourable Member has raised, is derived from that notion of equality and dignity. What it says...
Well, to my honourable friend once again, and for the record, I think the Deputy Speaker is so many leagues above me that I'm not sure that my honourable friend's right. Except, if one takes his point, the equality of humanity, the equality before God, which I believe is a matter of faith, that does not mean that rights are always applied equally. And even in this bill, on the right to life, that most essential right, you see it qualified in the case of self-defence. So rights immediately become relative.
Rights are indeed qualified. This does not mean rights are relative. This is an important distinction. The subclause which the Honourable Member has referred to in the bill indeed establishes a right, but says that under certain specific circumstances, that right may be qualified or overruled. That is not a statement that the right is relative. It's not a statement that the right to life contained in the European Convention of Human Rights is purely relative. It's not a statement that below the threshold of the qualification, and I come back to the threshold of the qualification, below the threshold of the qualification, in other words, the specific circumstances in which that right may be suspended, below the threshold of that qualification, and this is what makes rights quite different from any other form of moral law, below the threshold of that qualification, your possession of a right is not relative to the costs or benefits of upholding it in any particular case. On the question of the right to life, your right to life may be suspended at a certain threshold. Those thresholds described in the European Convention include thresholds on civil disorder. They include thresholds relating to military law. But below that threshold, your right to life cannot simply be looked at in terms of the costs or benefits in upholding it in any particular case. In other words, I give way.
To my honourable friend once again, but this right is so clearly absolute because if you think of the old Riot Act, which provided for the militia to start shooting, that was a decision at that time to maintain order required immediate use of fatal force. That is no longer thought to be appropriate. It is therefore a relative judgment relating to the balances of the individual and the collective.
Mr. Deputy Speaker, I think we need to be very, very clear what we mean by relative. There is a notion of relative, which the Honourable Member for North East Somerset is rehearsing, which is simply to say that rights and moral values evolve in a historical context. It is simply a question of historical fact, as the Honourable Member says, that different cultures at different times have taken different moral positions. Aristotle, along with his other great observations, of course, believes that women and slaves lacked souls. Today we realise not simply that it's relative, not simply that he thinks one thing and we think another, but that he is wrong. He is wrong because moral language is implicitly not relative. Moral language is, in its very structure, absolute. Moral language does not say, I don't happen to like you killing someone, but if you want to kill someone, that's up to you. In other words, moral language doesn't say that killing someone is like you liking chocolate ice cream and myself liking strawberry ice cream. Moral language says it is wrong. It ought not to be done. Moral language is about questions of ought, not questions of is.
But, Mr. Deputy Speaker, it goes immediately on from saying it ought not to be done to add, except in the certain circumstances.
Rory Stewart.
Try again. The central point to be made is the notion of moral obligation, the notion of what ought or ought not to be done, relies on two conflicting principles which connect at the moment of the threshold. Those two conflicting principles are the notion of the inviolability and dignity of the human being on the one hand, and on the other hand, a consequentialist or utilitarian argument of the greatest happiness of the greatest number. Philosophically, the origins of these two types of argument are entirely distinct. One of them is a deontological argument. It simply states the dignity of the human being and their inviolability. The other is an instrumental argument. It's an argument based on consequences or results. Our legal system, and indeed our moral intuitions, combine these two, and the two meet at a point of threshold. This is what we mean by ought. What we mean is exactly what the Honourable Member for North East Somerset has said. The individual ought not to be treated like this, except in very extreme circumstances at a certain threshold, and below that threshold, the individual's possession of the rights is not a function of the costs or benefits of upholding it in any particular case. This is important because this is a distinction between a relative position which says, I can take your life whenever I feel like it on the basis of no moral argument and no logical position, and a separate position which says, Mr. Deputy Speaker, I may not take your life. There are certain extreme situations in which it could become legally permissible to do so, but I may not. The distinction between human rights and a relative position is a distinction on permissibility. It's a distinction on what may be done. Before the Honourable Member for North East Somerset intervenes again, just to be absolutely clear, the distinction is this. When I say, Mr. Deputy Speaker, that somebody has a right not to be tortured, I am saying they may not be tortured. I'm not saying they will not be tortured. There might be a horrible situation in which their government tortures them. The statement is a moral statement. It's not a prediction about the future. It's a statement about what we morally give permission to do. You may not be tortured. You may not be killed. It is then possible to state certain threshold circumstances in which our moral intuitions in terms of human rights shift to moral intuitions in terms of a consequentialist worldview, in which we say one might be killed for the benefit of a million. These are nice questions of moral philosophy. Usually they don't come up in our everyday life. Our everyday life is based on the dignity and inviolability of the human being, regardless of circumstance.
Thank my honourable friend for giving way, and he's making a very powerful argument. What he highlights, to my mind, is a key difference of civil law and common law. In common law, we would take a utilitarian approach. If a plane was heading to London with 100 people on board and a nuclear bomb, we would say, save the city. But in Germany, under the civil law code, they would say, you can't touch the plane because of the inviolability of their right to life. And that is, to my mind, at the heart of part of the problems that I've been wrestling with this bill.
Thank you, Mr. Deputy Speaker. The example of the plane is a very, very good example. It's an exact example of where our moral intuitions collide. My instinct would be that neither ourselves nor a German legislator would be comfortable with the decision either way. These are terrible, terrible decisions in which two very, very deep moral intuitions. The moral intuitions that individuals should be treated as ends in themselves and not means to an end, which is, of course, why the German Supreme Court holds, as the honourable member has so rightly pointed out, that a plane could not be brought down in those circumstances, could not be brought down in those circumstances because the German Supreme Court feels deeply that if you were to bring down those people in that circumstance, you would be treating them as a means to an end rather than an end in themselves. You would, in effect, be doing to them something similar to the idea of moving ahead with killing one person in order to harvest their organs to benefit 5 others. The idea being that the calculus that 5 have been benefited is not enough to outweigh the harm done to 1. That's an important moral intuition. But, of course, the honourable member is correct. In the end, most of us would disagree. I personally would disagree. The honourable member presumably would disagree. In a situation of that sort, where 1 million people are going to be killed by an atom bomb, another deeper, stronger moral intuition comes in, which we often describe in terms of common sense, but is in fact a utilitarian calculus, which is to say there is a certain threshold of absurdity beyond which the protection of the rights of the individuals in that plane no longer makes sense. The Honourable Member North East Somerset has been very good at pointing out the contradiction that these are 2 separate philosophical principles, and the question of where that threshold comes in, that terrible judgment which a politician would need to make in that situation, is not one that can be resolved except through a very, very deep understanding of the particular facts of an individual case.
I'm grateful to my honourable friend, and I'll try and make this my last intervention, but I think once you accept the threshold, it has become fundamentally arbitrary, and it is merely a matter of arguing where that threshold should be set. And therefore, it is the question of the legitimacy of who sets that threshold, whether it should be the Queen in Parliament or whether it should be a foreign court.
Thank the honourable member for North East Somerset very much. There is a disagreement here, and it's not a disagreement that we can paper over. The question is, where should we put the weight of sovereignty? How important is sovereignty? Does sovereignty confer some form of immunity? Is there some magic in this chamber which allows the legislators in this chamber to do whatever they want? Is it the case, as Lord Hoffman suggested in the judgment, that if this chamber wished, it could simply flout human rights? And is that statement made by Lord Hoffman, is that statement a statement about political fact and institutions, or is it a statement about morality? Is it that we think that it's simply a fact that this Parliament could do whatever it wanted, or do we feel this Parliament ought to be able to do whatever it wanted? And on this is based our whole conception of democracy. Those who feel that this chamber not only could but ought to be able to do whatever they want are basing themselves on one principle only, which is the principle of majority representation. Where I suspect there may be a disagreement between myself and the honourable member for North East Somerset is the notion that democracy is not based on one but on 2 principles, on majority representation and on the protection of minority rights. And that in the absence of the second criteria, we cease to be, in the full sense, a democracy. This is a very difficult argument to make, because, of course, in this country, we have every reason to be proud of the performance of this Parliament. Although theoretically, constitutional anxiety leads us to believe that this Parliament could do truly barbarous things, as a matter of fact, this Parliament has not. In fact, consistently, this Parliament has shown itself very, very respectful of the unwritten laws of the British Constitution. And when Parliament has attempted, as indeed, Mr. Deputy Speaker, Parliament attempted in the abolition of the House of Lords to fundamentally change the Constitution of the United Kingdom through a simple majority in the House of Commons, Parliament refused to take that opportunity. Parliament backed away from it. It's Parliament's reluctance, Parliament's innate conservatism, its caution around issues of the Constitution, which has meant that right the way from 1911 to the current day, people pushing for a written constitution or more formal constraints on the power of Parliament haven't won through. This is good, and it shows two very positive things. It shows, firstly, a very important principle, the principle of common sense, something that everybody in this room agrees with, which is we do not want to live in a world of technocrats. We like the fact that the British public has a say. We like the fact that the common sense of the British public permeates this Parliament. That at our best, and we're not always at our best, but at our best, we are a lens that connects the executive to the voting public. That we act as a mediator between public opinion, between the sentiment and imagination and culture of the British people on the one hand, and the laws passed in Parliament on the other. Nobody in this chamber wishes to pass to a world where we vest our power in technocrats or experts, where we somehow say that some form of Mario Monti is going to come in with some great insights who knows what's best for the people. It is our unruly common sense which means that the public has tended to respect its landscape, has tended to challenge things that the government may wish to do in relation to wind turbines, has refused to cooperate, as indeed the French public occasionally refuses to cooperate over farming, with the theoretical ideas of experts in government. The second reason to be proud of the sovereignty of Parliament is that Parliament reflects a culture. But the question to the honourable member for North East Somerset, who has been one of the great supporters of untrammelled parliamentary sovereignty, is do we have the confidence that the unwritten rules, the culture of this House, the deep understanding of the history of the British Constitution, which meant in 1911 that members of Parliament were very, very cautious about changing the Constitution, still holds? Or did we, in the vote over the House of Lords bill, come very, very close to the brink? Was there a possibility that we are suffering from a collective amnesia, that one can no longer say that the British Parliament is so deeply entrenched in its constitutional history that it can be guaranteed never to fundamentally change the British Constitution? If we are moving into a world in which we are getting into that danger zone, at that point, my belief is we need to follow the example of every other advanced democracy in the world, which is to separate constitutional law from normal law, and to say that for a fundamental change to the Constitution, which affects the rights of citizens, this is why this is relevant to the European Court on Human Rights, we must ensure that special procedures are followed. The special procedure that we have tended to develop through precedent over the last 40 years is, of course, a referendum. We may not want a referendum as the fundamental way of changing the Constitution. We may want to adopt a different procedure, a two-thirds majority, a free vote in the House, which of course is what the previous government used to deal with the issue of the House of Lords. But we are moving to a world where we need a proper procedure. And the reason why this is relevant to the debate today is because the question of parliamentary sovereignty in the relation to the European Court is at the nub of this issue. The argument against the European Court cannot simply be that Parliament is sovereign, absolute, and always right, and should never be challenged. We actually have developed an entire doctrine of international intervention around the notion that sovereignty does not confer immunity, that the rights of the individual citizens in a country can trump the sovereignty of a parliament. The second argument that can be made, moving on then from sovereignty, and with apologies for having paid so much attention to sovereignty, to move quickly through the second argument, is the question of moral relativism. And it may be that in the exchange with the Honourable Member for North East Somerset, that's been covered adequately. The idea is, Mr Deputy Speaker, of moral relativism, that the question of prisoners voting is purely relative. I like chocolate ice cream, Mr Deputy Speaker, maybe you like strawberry ice cream. These are questions of taste. They're not questions of moral decision. The Spanish believe prisoners should have votes. The British believe prisoners shouldn't have votes. It's purely relative. There's no way of resolving these things. That is a very dangerous argument. To say these things are purely relative is a very dangerous argument because, of course, all these questions about rights are fundamentally issues about morality. And moral language is a statement about what is right and what is wrong, what we ought to do, what we ought not to do. It is not a statement of personal taste. It isn't a statement akin to saying, I like red, you like blue, and there's no discussion about it. What one says is, you are wrong. We must believe it is possible to resolve the question of who is right and who is wrong over the issue of prisoners' voting, and to resolve it through moral investigation and debate.
Thank my old friend for giving way. He's been very generous with taking interventions. I would say it's a slightly different issue, which is the Spanish think prisoners should have the votes, the British do not, and the error is the one-size-fits-all approach taken by the European Court. What we should have is an acceptance that different countries will arrive at different solutions and not just thrust a uniform morality on all.
A very powerful argument made by the honourable member is indeed the argument made by Lord Hoffman very powerfully. Lord Hoffman argues, in exactly the way that the honourable member has, that universal rights, such as the European Court of Human Rights, are simply aspirational. Any universal code is aspirational, but it is always national in its application. In other words, the argument made by Lord Hoffman and by the honourable member is that the European Court of Human Rights and the Convention is purely aspirational. It is a good way of encouraging people to behave better. It is a good way of doing political lobbying. It is a good way of applying pressure. But in its application, human rights can only be national. The notion being that human rights are relative to a particular historical or political context. The idea being, Mr. Deputy Speaker, that the question of whether prisoners should vote is not something that can be determined in Lord Hoffman's views or the honourable member's view, but not in my view. In Lord Hoffman's view or the honourable member's view, this question should not be determined by moral debate. The question is absolutely specific to a particular historical or national context. The real answer to whether prisoners should vote depends on the difference between Spanish culture and British culture. This is, of course, a position that I reject. It's not a position I can accept because rights are absolute. Rights are universal. Rights are inviolable. It cannot be the case that your possession of rights is relative to the particular circumstances of a particular culture. It cannot be the case that the mere fact that you live in Saudi Arabia means that you have fewer rights as a woman. It cannot be the case that the mere fact that you live in Taliban Afghanistan means that you do not have freedom of the press. These rights, if they are rights at all, rest on one fact and one fact only, the fact of your humanity, not the fact of your nationality.
I'm on friend for giving way again. I think Lord Hoffman said that human rights are universal in their abstraction, but national in their application. And I think what he's saying is one size fits all doesn't work. You need room for what used to be called subsidiarity, but in this debate has been called proportionality, or indeed the margin of appreciation. I think the margin of appreciation is central to getting the right settlement that all countries can live with.
Honourable Member brings us very neatly to the third question in this whole bill, which is the question of subsidiarity and triviality. So to move on from these big questions of sovereignty and meta-ethics, the central question that the honourable member has made, which is a really, really important one, is a question fundamentally of triviality. Lord Hoffman may be suggesting that although at some theoretical level it may be possible to resolve whether or not prisoners should vote, as an actual practical point, Mr. Deputy Speaker, the issue to some extent doesn't really matter. That it's subsidiary, it should be left to individual countries because it's just too disruptive to the international system to try to impose, as the honourable member says, a one-size-fits-all. That getting into that debate at all, that trying to resolve the issue of whether or not prisoners should have the vote, is simply disruptive to the international system. This is a very, very strong intuitive argument. It's one that we might have a lot of sympathy with in this House as politicians. It's not obviously a moral argument. I think as a moral argument, Lord Hoffman's argument doesn't hold water. It cannot be the case as a question of ethics that nationality is the prime determiner of your rights. But it may be true as an issue of practicality. It may be true in terms of the sanity of the international system that you allow some flexibility in the process. The problem with that, however, and the reason why, in the end, although that's really tempting, really, really tempting, one should not go down that path, is twofold. For a legal system, the question of triviality cannot be relevant. It is not possible for a judge to simply determine a case on the basis of whether or not they think the question of prisoners voting is or is not, in the grander scheme of things, an important question. The judge is there to try to make a decision on the basis of the law, which is why we often get frustrated. We often find it very peculiar, Mr. Deputy Speaker. The classic example, of course, which is one of the things that I personally hate about the European Court of Human Rights, was the case that was brought by the man who didn't want to give his name when he was caught speeding. Classic example. Went all the way up through the court system. He argued that he should not be obliged to give his name when he was spotted by a speeding camera because he had a right of privacy. He had a right to silence. And he objected to the fact that he was going to be fined for giving his name. The courts did not, through the whole process, say, this is a minor trivial issue, this is a minor speeding fine, we're not interested. It went all the way up to Lord Bingham, who at great length and with enormous politeness explained to the gentleman that he did not think that this gentleman's right of silence extended to him not giving his name in relation to a speeding camera, at which point the gentleman applied to the European Court, and the European Court, perhaps to the delight of speeding motorists, seemed for a moment in favour of majority judgment to say this gentleman should not give his name because of this question of right of privacy. These triviality arguments, in other words, don't operate. But more importantly, much, much more importantly, judges are not politicians. It is not for a judge to determine whether it would be politically disruptive or inconvenient for a particular judgment to be passed. They may intuitively, in the back of their mind, be influenced by what they read in the newspaper. They may be anxious that if they pass a judgment which is objectionable to the public, that will undermine the legitimacy or the reputation of the judiciary, but that cannot be a formal consideration in their decision. It cannot be that the European Court, in making a decision, a European court, in other words, a court which by its very nature has sanctions, that court can look at the question of whether making a decision is disruptive to the international system or undermines the legitimacy or the reputation of the court itself. These cannot be the terms on which either moral or legal decisions are made, although we may often feel they are the points on which political decisions can be made. And to give a very good example of that, if we take the question of gay marriage, which has been a very controversial issue in this chamber, it makes perfect sense for a political chamber to say this is a philosophical question which we, for political reasons, feel this is not the appropriate moment to raise. It would cause too much disruption, too much unhappiness. But at the point at which the issue is raised, at the point at which it is put to the vote, at that point it no longer makes sense to talk purely in terms, particularly in a case that relates to morals or ethics, purely in terms of public opinion and disruption. It becomes necessary to look at it on the merits of the case and examine it philosophically. So the argument why the European Court should not get involved in prisoners' voting cannot be that it's trivial, disruptive. The reason why there needs to be subsidiarity, the reason why there can't be one size fits all, cannot simply be, from a moral or a legal point of view, that it causes inconvenience to do so. Is the Honourable Member trying to intervene? No. To move on to the fourth and final part, then, of the argument. There are three arguments which we've considered which do not hold water about the European Court. The first is the argument that the European Court should not exist simply because Parliament is absolutely sovereign. As a moral principle, as opposed to a statement of constitutional fact, that is objectionable. And indeed, the current evolution of British culture and the behaviour of the British Parliament over the last 20 years suggests that it would be very dangerous to put the entire reliance of our constitutional system and the protection of rights on the individual decisions of a temporary majority in a sovereign parliament. The second argument that we have rejected is an argument that states that questions such as prisoners' voting rights are purely relative. that there are no moral absolutes here, that these questions cannot be resolved in any philosophical sense. To return to the trivial examples I produced, that somehow moral arguments are simply a question of you think this, I think that, and there's no way of resolving, that it's all entirely relative. You like chocolate ice cream, I like strawberry ice cream, and it's just a question of taste. No. We believe very, very strongly that moral arguments are different from arguments of taste. There is an answer to these questions. There is an answer to the question of whether prisoners should have voting rights. It is based on whether we believe the dignity and inviolability of the prisoner's status as a moral actor, as a human, requires them always in all circumstances to have a vote or not. Personally, I feel that the argument is not convincing. A prisoner is not entitled, as a fundamental element of their human dignity and inviolability, to a vote in all circumstances. That, however, is not, I believe, a question simply of taste. It's a question of moral argument. The third argument which we are rejecting here is the argument that simply it's inconvenient to talk about these things, that it disrupts the international system. This is a very, very tempting argument because we set up this court. David Maxwell Fyfe essentially drafted this document, steered it through. Britain is in the rather unfortunate situation of embarrassment. This was a court we were very proud of, and if we were going to tease ourselves a little bit, we would probably point out that for 40 years we rather enjoyed the fact the court was telling other countries how to behave. We felt the point about this court, probably intuitively, was we were hoping this court would drag other people up to what we rather pompously felt was our level. We only became anxious about this court when this court turned round and started telling us what to do, as opposed to telling foreigners what to do. And this is a rather difficult and embarrassing situation. We liked the court when it insisted that countries in southern Europe should have habeas corpus. We liked the court when it did a really good job on insisting there should be no detention without trial in southern Europe. We only became anxious about this court when those very countries that we cheerfully made accord with British legal norms for 40 years turned round and with prisoners' votings tried to demand that we accorded with their legal norms. So there's a very good reason for us to feel politically, institutionally, in terms of public opinion, we don't like the idea, and we would allow subsidiarity simply to avoid a political embarrassment. However, that is not, as I've argued, either a moral or a legal position. It is purely a question of expediency and convenience. And on expediency, no moral principle can be based. Which brings us to the fourth and concluding argument, Mr. Deputy Speaker, which is what should we really be doing about the European Court? What we should be doing about the European Court is not giving up on the notion that there are inviolable human rights, not giving up on the notion that those human rights are universal, not giving up on the notion that the sovereignty of Parliament must respect the rights of the individual, not giving up on the notion of moral absolutes, or indeed taking on the notion that some political expediency can override moral or legal principles. What we need to do is to go back to the fundamentals and challenge the moral and legal argumentation of the European Court. And we would do so in exactly the way that the Honourable Member who has proposed this bill, the Honourable Member for Dover, has so eloquently explained. The Honourable Member for Dover is in essence not, from my point of view, producing something that should lead us to leave the European Convention. What the Honourable Member for Dover is pointing out is that the current operations of the court are resulting in absurd, surreal consequences, and that the way to address that problem is to look again at the document, at the European Convention on Human Rights, to look carefully at how it was drafted in 1950, and to look carefully at what ingredients lie within that document and how much latitude that gives the court. The court, which a year ago had 100,000 cases waiting to be heard, an absurd number of cases waiting to be heard, needs to say no to far more cases, needs to understand that the 1950 drafting of this allows very little latitude for the court. That there are many issues that the court is currently engaging with which is outside the purview of the original Convention on Human Rights. A classic example of that is prisoners voting. The point is not that the question of prisoners voting cannot be resolved legally or philosophically. The point is that the question of prisoners voting cannot be resolved on the basis of the European Convention of Human Rights. There is nothing within the European Convention of Human Rights which gives sufficient detail or cogency to allow a judge, purely on the basis of the nostrum of a democratic society, to derive from that very vague and abstract principle the conclusion that prisoners should have a vote. That could be done, but not by the European Court. It is something that could be done by a British Parliament, and it's something that could be done by a British court because it requires a much deeper background of legislation. It requires, in our case, the corpus of the common law. It would require in Spain the corpus of their own continental legal system. It requires far more than the very brief statements in the European Convention on Human Rights to reach that kind of conclusion. This is not to say the European Convention on Human Rights is useless. Far from it. The European Convention on Human Rights and its fundamental principles is an incredibly useful dynamic document. It is unambiguous and clear on questions, for example, of torture, as it should be. And it makes every sense for the European Convention on Human Rights and for the European Court to rule on the protection of fundamental political rights of the sort contained in that document. It is not that torture, genocide, arbitrary arrest, arbitrary imprisonment are somehow the only issues that matter. There are many other issues of human rights that matter, but those are the only issues covered in that convention. They are the only issues on which this court should be ruling, which is why the Brighton Declaration, brought together by this government as the President of the European Council, the statements of the Secretary of State, the statements of the Lord Chancellor are correct. What we require is a fundamental reform of the European Court. What we require is to radically reduce the number of cases, to clarify the legal and philosophical basis of this court, to determine what cases they should be ruling on and what they should not. And the reason why all these notions, which the Honourable Member for Dover has so eloquently raised, of subsidiarity matter, is not as a matter of moral, legal or philosophical principle, but a matter of the ingredients of the Convention on Human Rights. These things are subsidiary because they are not covered in that document. And rather than losing confidence in the notion of rights, rather than losing confidence in a convention which we were proud to create, which a Conservative Member of Parliament and a Conservative Lord Chancellor created.
I thank the member for giving way. He's giving a very eloquent defence. But it would seem to me that the logic of his position is that we shouldn't have a European Convention of Human Rights or Court. We should have a world convention. Is that his position?
Rory, Stewart.
It's a very telling intervention. The answer is that we have and ought to respect and have signed and uphold the United Nations Declaration on Human Rights. It exists. We are signatories to it. Yes, we are signatories to it.
We are signed it. We signed up.
As the Honourable Member for Beckenham points out, we are signatories to the UN Declaration on Human Rights. We were the first signatories to the UN Declaration on Human Rights. The UN Declaration on Human Rights in 1947 is the precursor to the European Convention. We have signed it. We should respect it. Should we establish a court in order to uphold the information in the UN Declaration on Human Rights? That I think we should be very cautious of doing. The UN Declaration on Human Rights includes, as Ms. Deputy Speaker is aware, it includes many elements which would be difficult for a court to rule on, and which are difficult in their application to the 200-odd members of the United Nations. For example, The UN Declaration on Human Rights includes a right to paid holiday. This is a difficult right to imagine in Chad or Mali or the Congo. It's difficult to imagine what would be involved in somebody in a developing country on $1 a day asserting their right to a paid holiday, and it would therefore be difficult to imagine the existence of an international court that would rule on that kind of information. Nevertheless, in certain set circumstances, indeed, we should respect the UN Declaration and international courts. A classic example of this is, of course, the International Criminal Court. Another example of this would be the International Tribunal on Crimes in Yugoslavia. In all these cases, with the ICTY and the ICC, Britain is a signatory and upholds the rulings of that court. Those rulings, of course, deal with crimes against humanity. And this is an important point. To go back to the beginning of the argument, we sign up to these things because we accept that crimes against humanity are crimes against humanity committed anywhere by anyone in any circumstance. And the sovereignty of an individual parliament or an individual country does not trump the individual's rights to be exempt. Not even the sovereignty of this parliament. Not even this parliament ought to be allowed to commit, to put the most extreme situation, crimes against humanity. These things we sign at an international level, and we constrain the power of our parliament as we should in those specific cases. In the other cases, the moral, legal and philosophical arguments are better conducted in a domestic context. Give way to the Honourable Member for Beckenham.
Thank you, Mr. Deputy Speaker, and I thank my honourable friend. Is it not the case that the International Criminal Court and the International Criminal Tribunal for the former Republic of Yugoslavia only try crimes against humanity and actually crimes of genocide if there is no way that a national jurisdiction will deal with that problem? Only then does it go to the International Criminal Court, or ICTY.
Rory Stewart.
This is a very fundamental principle the Honourable Member for Beckenham is absolutely correct to raise. We have, of course, within the international system, an important conception of state sovereignty. The only argument that's being made today is that state sovereignty is not absolute. It doesn't trump everything else. But again, to return to the language that the Honourable Member for North East Somerset doesn't like, up to a certain threshold, state sovereignty obtains. There is a point up to which the ability to attempt to resolve it domestically must be given an opportunity. But at a certain case, at a certain point, when the state concerned has failed to deal with crimes against humanity, it is then not only legal under the international system, but morally correct for an international court to overrule the national government.
Yes, can I just, I thank the member for giving way. Can I just press him a little bit harder on his position on this World Court of Human Rights? Because it does seem to me that the logic of his position is that the scope of the European Court should be extended as far as it possibly could, given that these things are absolute and not relative, as he has been saying. Is that his view?
Rory Stewart.
This is a very, very interesting and important question. The answer, of course, is that when David Maxwell Fyfe, who, as you said, is, of course, somebody who we should be proud of on this side of the House, and indeed Hartley Shawcross, who the other side of the House is equally proud of, brought together this convention, the objective was to try to spread it as widely as possible. And indeed, the British government has had as its policy for over 60 years now an attempt to push it as far as possible, which is why the European Convention now extends a very, very long way beyond the boundaries of the European Union and takes in countries like Russia. This is because we believe the ingredients of the European Convention on Human Rights are basic, inviolable and universal dignities. Anybody who wishes to sign up to the European Convention, we would absolutely encourage them to do. Any country that wishes to join, to sign up to those declarations and that wishes to have itself held to those high and exacting standards contained within this document, should be welcomed in doing so. But if, and this is where the Honourable Member for Dover is absolutely correct, if this court is going to survive at all, it needs to narrow its focus drastically. If it's to have any kind of credibility or legitimacy in the long run, it cannot continue contributing to a situation where the British public ends up feeling that human rights are trivial, that human rights are an excuse, that human rights are a charter for triviality, that human rights have the same relationship to real rights as health and safety does to real health and safety. In other words, that it is a factory for lawyers and insurance claims. To return to its fundamental principles, it needs to remember what it's there to do. And it's on this, Mr. Deputy Speaker, that I really will conclude. The European Convention on Human Rights isn't something that we should set aside as a party by suggesting that human rights don't exist. Human rights do exist, and all of us are very proud of living in a society in which our rights have been protected in different forms since Magna Carta. We didn't use the word human rights really until the French began to popularize the word in the late 18th century. Until then, it was really a specialist word that nobody in this country would have used. And indeed, it's not until after the Second World War that anyone in this country really started using the word human rights. But the basic notion of the rights of man is something that we've had in this country for 800 years. The basic notion is that the human is dignified and inviolable. Certain things may not be done to that individual. That anyone, anywhere, who's treated in that fashion is wronged. That their possession of that right is not relative to the costs or benefits of upholding it in any particular case. The European Convention, drafted by ourselves, enshrines those notions of basic decency, of equality of humanity, and of inviolability. The problem with it is not the sovereignty of Parliament. The problem is not that rights don't exist. The problem is not that it's politically too complicated. The problem is that we have allowed it to stray from its fundamental job. It was given a very narrow task and a very narrow focus, which was, broadly speaking, to deal with crimes against humanity. We should therefore join the honourable member from Dover very, very strongly in demanding that the caseload of the European Court is radically reduced. The principles of subsidiarity are radically increased, and the European Court ceases to get involved in situations which it is neither in principle, nor in ethics, nor in law competent to handle. Thank you very much indeed.